Morning, everybody. Carrying on then with the final, I think the final 6 articles, and then we'll delve into the large decision of June the 6th, 2014. But first of all, this is carrying on from where we left off. Harassment trial set. That's good. So this is February the 12th, 2013. Harassment trial set for former DA Kratz. Madison, Wisconsin, Associated Press, former Wisconsin prosecutor accused of sending racy text messages to a domestic abuse victim is due back in court next week to settle sexual harassment allegations. Ken Kratz resigned from his position as Calumet County District Attorney in 2010 after the Associated Press reported he tried to spark an affair with a woman while he prosecuted her ex-boyfriend for domestic abuse. Stephanie filed a federal lawsuit against Kratz, alleging Kratz sexually harassed her. She's seeking unspecified damages. A trial is set to begin in the case on February the 19th. On February the 19th in Milwaukee. The State Office of Lawyer Regulation has recommended the State Supreme Court suspend Kratz's law license for 6 months. The court has yet to issue a decision on the recommendation. And moving swiftly on, keep her moving, as they say. That off, make sure this one is set, ready to go, which it is. So then hopefully we shall get the right one up. Here we go. Yes, Sexton lawsuit against former DA Kratz settled. Green Bay, Associated Press, February the 13th, 2013. A settlement has been reached in a lawsuit against former Calumet County District Attorney accused of sending racy text messages to a domestic abuse victim. Federal court records show. Stephanie Van Grohl accused former prosecutor Ken Kratz of sexual harassment for allegedly sending her a barrage of messages, including some propositioning her while he was prosecuting her ex-boyfriend in 2009. Kratz resigned as DA in 2010 after the Associated Press reported he had tried to spark an affair with the woman. More women later came forward and accused Kratz of sexual assault. Yes, it was very much the Associated Press that caused him to resign. The OLR decided to sit and do nothing to begin with. No details of this settlement were released. WLUK TV reported Tuesday. Van Grohl was seeking unspecified damages in her lawsuit. The trial had been scheduled to begin next week in Green Bay. So he settled before. Kratz, who was 50 when he sent the text, called the then 25-year-old Van Grohl a hot nymph and advertised him as the prize. She reported the text to police. State prosecutors declined to charge him, and so she sued. Notice no more Rob Bellin. It was an interesting comment. I said to him once, you know, Kratz, during all this time, had like 4 different attorneys. And he said, when you're facing that much trouble, you need plenty of lawyers. Kratz's attorney, Ted Tornhill, and Van Grohl's attorney, Michael Fox, did not immediately respond to Wednesday's phone messages from the Associated Press seeking comment. Kratz asked for the lawsuit to be dismissed in 2011, arguing that the flirtatious text messages that he sent weren't sufficient to support Van Groll's assertion that her constitutional rights were violated. Wisconsin's offer of lawyer regulation recommended that the state Supreme Court suspend Kratz's law license for 6 months. Kratz asked for just a formal reprimand, saying he had suffered enough, had been forced into bankruptcy, and deserved a chance to rebuild his career. Rebuild your career, my goodness. He testified at a hearing last year that he was addicted to sex and prescription drugs at the time. The court hasn't issued a decision yet, but we will be getting on to that decision. No idea. It's just that there were some long words in there. I don't know. Okay, let's move swiftly onwards. There we go. Sexting DA has license suspended. Update. June 6, 2014, former Calumet County District Attorney Ken Kratz, who resigned after sending racy text messages to Stephanie, has been suspended for 4 months by the Wisconsin Supreme Court. Kratz resigned as DA in 2010. He had had that position for 18 years. 18 years of sheer hell for people in Calumet. After it was reported he had tried to spark an affair with Stephanie Van Groll, a woman for whom the DA's office was pressing charges. And as I say, I'm sure it was Marinette County he was in before then. And there are definite allegations, and it's likelihood that he was practicing his sexting and other misdemeanors back then. He was considered one of these people that you know would quite easily harass people. Kratz resigned. He'd held for 18 years. Reported tried to spark an affair with Stephanie Van Groll, who he was pressing charges against the boyfriend of. The situation triggered a Department of Justice investigation that yielded no criminal charges. The Office of Lawyer Regulation initially dismissed the case, though reopened it after the Associated Press obtained an investigative report. Now, I do get a sense that somebody somewhere did not like the idea of Ken Kratz getting away with this. After the Van Groll story broke, other women came forward as well. Kratz eventually pleaded no contest to 6 misconduct counts. At the time the DOJ investigated Kratz, he was the chairman of the Wisconsin Crime Victims' Rights Board. He resigned after the allegations came to light. All right. Kratz now has a criminal defense law practice in West Bend. That's that part of the toilet system, is it? Maybe I'm being unfair to West Bend. The justices, in a colourful opinion Friday, ruled that Kratz will not be able to practice for 4 months, effective July the 11th. The OLR had argued for a 6-month suspension, since Kratz then would have to apply. That was what it was, yeah. If it was 6 months, he would then have to apply to have his reinstated. But the referee in court, weighing mitigating factors such as his successful completion of the Wisconsin Lawyers Association program through the state bar. The court also asked Kratz to pay nearly $24,000 for the costs of the proceeding, despite Kratz's objections. In short, whatever his qualities and accomplishments as a lawyer, Attorney Kratz proved himself during the period in question to be sanctionably sophomoric, according to the majority opinion. According to a statement attributed to Kratz that was revealed Friday, he is happy the court has finally ruled in the case, which has unfortunately defined my personal and professional life since the fall of 2009. No, your bad reputation goes further back than that. I once again apologize for the embarrassment and dishonor I have caused my family, the Calumet County District Attorney's Office, and the legal profession as a whole. According to the statement, I am very pleased to recognize that today's sanctions applied to an incredibly selfish and arrogant public official, thankfully a person who no longer exists. Rot nonsense. Kratz had argued that the situation drove him into bankruptcy and that his actions during that period were fueled by drug and sex addictions. According to Fabian's statement, Kratz also shot back at OLR for filing allegations that he said never happened. According to the court's opinion, Kratz asked Bangrol if she was the kind of girl that liked secret contact with an older married elected DA, the riskier the better. He also called her a hot nymph and called himself the prize. According to the opinion, Kratz told a Calumet County social worker that he wanted a trial to be over because he wanted to leave for a trip to Las Vegas, where he could have big-boobed women serve me drinks. He also told another social worker that a reporter had big, beautiful breasts. In the opinion, the court lambasted Kratz's attempts to defend himself in the case, saying he had employed a tooth and nail litigation approach. He had asked the court to give him credit for the 5 months he stopped practicing law following the scandal, a request the referee and court denied. According to the opinion, he raised arguments that ranged from the incredible, e.g. disputing his text messages to Stephanie contained sexual overtones, to the hyper-technical, claiming the OLR complaint was barred by the civil doctrines of issue and claim preclusion because an OLR investigator initially declined to forward SGV's grievance for formal investigation, to the inconsistent, denying any recollection of making inappropriate comments to SS, but claiming credit for having recognized their inappropriateness and apologized, to the puzzling, arguing that he could not have told RH that a reporter had big, beautiful breasts because the reporter in question was beautiful, but not large-breasted. Let's just go through that again. This is so typical, isn't it, of, according to the opinion, he raised arguments that ranged from the incredible to the hyper-technical, to the inconsistent, to the puzzling. Justice David Prosser wrote a partial dissent to the opinion, saying it was unfair to make Kratz pay for the proceedings. He based this in part on his assertion that the OLR mishandled the case. He went through a divorce, he lost his home and his car, he filed for bankruptcy. It is unlikely that Attorney Kratz is in any position to pay $24,000 in court costs, according to Prosser's dissent. These extravagant costs will pose a serious hardship to Attorney Kratz. Oh, let me get my violin out. Where is it? Cannot be justified on the basis of the OLR prosecution and are manifestly unfair. Prosser, yeah, got a few words reminding that, eh, Prosser? Also said the matter became a political issue following Attorney General J.B. Van Hollen's decision not to pursue criminal charges. And as we know, Stephanie sued Kratz in federal court and the case was later settled. Let's pop up the next one. Now we're getting very, very up to date. That's 2014. Now this is, I want to say 2015, and it's December the 27th of 2015. Former prosecutor says Avery documentary is unfair. You know, Kratz, you should have just buried yourself in that cesspit and just left yourself there. Madison, Wisconsin, Associated Press. The prosecutor who put Stephen Avery in prison for killing a young photographer says a Netflix documentary chronicling the case is slanted towards the defense. Avery made headlines in 2003 when he was released from prison after spending nearly 2 decades behind bars for a rape he didn't commit. 2 years later, Steve was charged with killing Teresa Holbach, a freelance photographer who visited the Avery family salvage yard to take photos of cars on Halloween and was never seen alive again. A jury convicted Avery of first-degree intentional homicide, and he was sentenced to life in prison. WLUK-TV reports that filmmakers Laura Ricciardi and Moira Demas condensed hundreds of hours of footage into 10 one-hour episodes of the Making a Murderer series. The documentary features Avery's defense attorneys suggesting police planted evidence to frame Avery. Ken Kratz, the special prosecutor in the case, said the filmmakers never gave him a chance to answer the defense attorney's allegations. He said the documentary ignores up to 90% of the physical evidence that links Avery to the homicide. He said Netflix should give him an opportunity to tell his side of the story. This is all just total utter nonsense, you know. Everybody was asked if they would take part, but Ken Kratz just looked down on them. And this idea of slanted, you know, it depends where you consider the middle point is, you know. When the legal system is so slanted towards the prosecution as to beg a belief, then any tilting of that slant, even slightly towards Stephen Avery, and you're calling it slanted in favor of the defense, I don't think so. Let's just carry on down here. Anytime you edit 18 months worth of information and only include the statements or pieces that support your particular conclusion, that conclusion should be reached, Kratz said. He added that he's received dozens of threats and insults over the documentary. Yep. Suggestions that I shouldn't even be walking around was offered. The good cheer that I happened to develop stomach cancer for Christmas and really lots of really troubling pieces of correspondence, he said. The series producers told WLUK that Kratz was given opportunities to speak with them and they tried to show all viewpoints. We believe the series is representative of what we witnessed, Demos said. The key pieces of the state's evidence are included in the series, including the magic key and the magic bullet. Let's see where we are done. Just 2 more to go. So nearly done with this. Here we go. Prosecutor in Making a Murderer case says he'll write a book. Oh, fantastic, Kratz. And do you know what, Kratz? Despite your efforts to tell me to do so, I have never yet bought your book, and I certainly won't be doing so. What I did do, as I mentioned to you in our messages, I looked at hundreds of reviews of your book, which rated it as absolute garbage. And do you know why? Because they're right. Green Bay, Wisconsin. The man who prosecuted the case featured in the Netflix show Making a Murderer says he is writing a book. Ken Kratz says that he's writing about the case because the voice of slain victim Teresa Holbach has been forgotten. Kratz said he's grateful to tell the whole story. Stephen Avery served 18 years in prison following a wrongful conviction of rape, and 2 years after his release was charged in Holbach's death. He was convicted of first-degree intentional homicide. The Making a Murder series questions whether Avery was treated fairly and suggests the possibility that Manitowoc County Sheriff's deputies planted evidence. Wow. Authorities have denied that. Kratz has defended the prosecution and says evidence was left out of the series. The filmmakers have stood by their work. And as I say, I once got in touch with Michael Griesbach about his book, and he wrote back to say that, you know, he was staggered by the reach of the documentary, a testimony to their hard work and effort. Yes. Okie dokie, let's move on. One more article, which I particularly like because it's by Michael Cicchini. Critics Corner, Critical Omissions in Making a Murderer, ? By Michael D. Cicchini. And there is Michael's book, Convicting Avery. Let's read what Michael has to say. Probably noticed I've had him on a couple of times to chat about things. And I think he's pretty good friends with Professor Larry White, who was the confession expert that Dean and Jerry had got lined up, ready in case Brendan testified. Whenever I write a motion or a brief on behalf of a client, it inevitably requires that I quote language from a published case, the criminal complaint, or some other document. And nearly every time I do so, the prosecutor cries to the court, he's quoting that language out of context. As Christopher Hitchens said, no letters, please, about quoting out of context. One does not have to be a deconstructionist to know that quotation is out of context, or, as I always respond, far less eloquently than Hitchens, you can't just claim that I've omitted something without telling the court how the omitted material supposedly helps your case. Since Making a Murderer, Ken Kratz has been singing this prosecutorial refrain from the mountaintops, frequently stating that the documentary omitted essential information. For example, in the book Avery, Kratz and Peter Wilkinson complain that Making a Murderer omitted Brendan Dassey's May 13th interview. Prosecutors refuse to use the word interrogation. They claim that Dassey makes chilling admissions with reasonable specificity and almost no prompting by the investigators. According to the authors, these unprompted admissions include Brendan's statement that Avery burnt the rest of Holbach's purse's contents, including the victim's digital camera and phone, in his own bowel. I would not call Dassey's statements about the purse, camera, and phone unprompted. The more accurate description is that the interrogators extracted the information. In fact, they previously raised this topic when interviewing Dassey a couple of months earlier on March 1st. They were obsessed with these items and wouldn't take "I don't know" for an answer. The interrogation and extraction went as follows. Fassbender. What happened to Teresa's other personal effects? I mean, a woman usually has a purse, right? Tell us what happened to that. Brendan, I don't know what happened to her. Fassbender, what happened to her? Her cell phone. Don't try to think of something, just, I don't know. Did you see whether a cell phone of hers? No. Do you know whether she had a camera? No. Fassbender, did Stephen tell you what he did with those things? Brendan, no. Fassbender, I need you to tell us the truth. What did he do with her possessions? I don't know. Wiegert, Brendan, it's really important that you continue being honest with us, okay? Don't start lying now. The hard part's over. Do you know what happened to those items? Brendan, he burnt them. How do you know? Because when I passed it, there was like a purse in there and stuff. What else was in there? Like garbage bags. Tell me what you saw exactly in there exactly. Like they were buried underneath a garbage bag that was, how do you know, or how could you see them if they were underneath a garbage bag? First, Brendan had no motivation to lie about whether he saw the purse, camera, or phone. By this point in the interrogation, Wiegert and Fassbender had already forced him to, quote, confess to rape and murder. Even Dassey would know that whether he saw these items was of no consequence to him whatsoever. Second, as the false confession expert Lawrence Wright stated in Making a Murderer. When interrogators repeatedly reject a suspect's answer and insist on honesty, it's not hard to translate. What that means is, don't tell us that, tell us something else. And Dassi did. And third, Dassi's story about seeing these items in the burn barrel was so unbelievable that even Uyghur questioned it. It is obvious to any fair-minded reader that Dassi didn't see anything. Rather, he was just changing his story to please his interrogators. They previously and repeatedly had made clear that if Dassi kept them happy, he'd basically walk free. The joke, as we know now, was on Dassi. In sum, everyone should be leery when a prosecutor says that a defendant made a statement with almost no prompting. And more importantly, everyone should be leery when a prosecutor says that Making a Murder has omitted things or has taken something out of context. The prosecutor is probably, well, taken things out of context. For more on interrogations, including how the police and prosecutor twisted Avery's claim of innocence into evidence of his guilt, see Chapter 6 of my newest book, Convicting Avery, The Bizarre Laws and Broken System Behind Making a Murderer. And I've actually got that book. It's really, very, very good. I say I've managed to have a couple of chats with Michael Cecchini. And I think the first time I came across Michael Cecchini was when Tracy Struncy had him on her channel in the very first Mammathon. And I'm pretty sure that watching live on that particular segment of Making a Murderer, I think there was about 750 people watching live at one moment, which was absolutely brilliant. And Michael Cecchini, really, really good author. I think I'm reading. Yeah, I'm reading. He did a book about Brendan and the one about Steve, and he also did one about Read Me My Rights, which I'm reading through, which he says is his first one. So maybe at some point in the future, get him back on for another wee chat. Anyway, let's finish that off. So next up, as I say, will be the same day as his license was suspended was the OLR decision, the eventual OLR decision, and we'll have a look at that in full, which will be quite a few pages, but probably split it up into smaller segments. Anyway, thanks for tuning in. Catch you all again soon. Bye for now.